100606. Defendant is present with counsel, Ms. Klossner, state represented by Mr. Willard. All right, so Mr. Willard, you were objecting but said that you were looking into some victim contact and research.
Yes,
Your
Your Honor.
position before I start?
Yes, the state would still object. We did come in contact with the mother of the child victim. She is objecting to early termination. She won't be here today, but she did relate to me over the phone that this still had a profound impact on her child. Her child basically suffers from depression and drug use is related. She thinks directly related, believes directly related to her experience, his experiences, and he's not been able to fully heal. I guess he is currently moved out of the house. He's of age, so he's currently moved out of the house and has basically cut ties with his family. So we would be objecting, Your Honor. I do have the probation officer here, Mr. Savalas. My understanding is she has done quite well on probation, has completed all of her terms and conditions. She has not had any violations since she's been placed both on community control and then when it was transferred to probation. So she has been in compliance with her conditions of supervision.
All right, and Mr. Willard, in regard to sex offender probation, is there any prohibition for early terming of sex offender probation?
There is under, it's under 948, one of the conditions that the court can consider in terms of denying early termination would be if the probationer qualifies as a violent felony offender of special concern, which under 948-06, being convicted of lewd marriage, she would. But my understanding, that would be the only prohibition that the court may consider in terms of denying that early
It's
term.
still discretionary.
Yes, Your Honor, it's still discretionary.
Prohibitive.
That's correct.
Okay. All right, Ms. Klossner, your question.
Your Honor, in mentioning 948-04, I would actually ask the court to consider that the current statute for 948-04 is different than the statute that was in effect when Ms. Peterson was sentenced in December of 2018.
Okay.
In 2019, that amendment changed and added a paragraph 4, which has very specific conditions for early termination. It's essentially the statement that says at the halfway point, probation must be terminated if all of these factors are met.
I believe that provision does exclude certain offenses, though, correct?
That's correct, it does. So my argument would be that the previous reading of that statute, as seeing as that was in effect when she was sentenced in 2018, would apply. And that previous version is the same in paragraphs 1, 2, and 3, but it does not include paragraph 4. So it does not specifically keep out her her charges.
Okay, but is your position that it's still just discretionary?
It's always discretionary essentially on the part of the court, other than in that new.
Right, and that's because 2019 changes.
Correct.
And so your position is that I would have to review the law as it was in place on the offense date as opposed to today?
That's correct.
State?
That's my understanding, Your Honor, yes.
Okay. All right, but we're still in the same sort of general parameters of it's discretionary for the court.
It would be discretionary of the court, that's correct, Your Honor.
Okay.
I would ask first to enter the attachments that were in the motion into evidence. It includes a letter from her therapist, Dr. Furbringer, dated May 10th.
All right, any objection to that, State?
Not at all, Your Honor, no.
And then there were also several character letters and letters of employment if the state has no objection to the court considering those.
No objection, Your Honor.
All right, so what I'll do is I'll just go ahead and take notice over the document in the court file. Is that
That's fine.
acceptable? All right,
And that was on
document
the,
110?
I'm sorry?
Is that document number 110 in the court file?
Yes, Your
All right, so I'll go ahead and take notice over the exhibits in document number 110 in the court file.
And just for the court's clarification, yesterday I did file a corrected renewed motion for early termination. The only change to that was in paragraph 3, where I corrected believe in the initial filing I had said January, which was the date that the sentence was issued. I had noticed that it was not their contract to December.
All right. All right, thank you. Any other evidence you wish to present?
I would ask to call Officer Savalas.
Okay. Is that you, sir? All right, if you have a seat in the witness stand, please.
Witness is seated, Your Honor.
All right, thank you. Witness is already been sworn.
Good afternoon, Mr. Savalas.
Hello,
Could you state your full name for the record and spell your last name?
Michael Savolas, S-A-V-O-L-I-S.
And could you tell us a little bit about your occupation, your experience, your background?
I'm a correctional probation specialist with the Florida Department of Corrections. I worked in this position for 24 years. The last 9 years I've supervised high-risk offenders, sex offenders, career offenders, conditional release cases.
Would you agree that there are more conditions on sex offenders on probation than there are regular offenders on probation?
About 95% of the time, yes.
And of those numerous conditions, what would you say you consider the most important of those?
Not to get rearrested is the number one. Following instructions and completing any special conditions related to the crime, like sex offender treatment, no contact with minors, no contact with victims, etc.
And how long have you been supervising Ms. Peterson?
Since December 16th of 2021.
And in the time that you've been supervising her, has she performed satisfactorily?
Yes.
Any specifics in that you think are examples of being satisfactory, whereas it might be unique to her situation?
Whenever there's a question about anything, she calls. If there's a gray area, she wants to make sure I know about it, I document it as she called. Or if she's had any questions or concerns about tickets, speeding ticket or contact with minors that's incidental, stuff like that, she'd call me and ask me if, tell me what was going on.
Has she been employed in the time that you've been supervising her?
Yes, she started off at a local law firm, and then she opened up her own business, claiming business.
And would you say that she works full-time, or is that a part-time thing?
Full-time, I would say.
And you said she owns this business, correct?
Yes, self-employed business.
And you've been able to verify that?
Yes, through licenses and through customers.
Has she had any violations in the time you've been supervising her?
No, she has not.
No technical, no substantial, nothing?
No.
Is that common in your position?
No, it's not.
Has she been attending therapy, and did she specifically complete sex offender treatment?
Yes, she went to therapy with Tony Kerbringer in Seminole County, and entered that treatment on January 5th of 2022, and completed on 12/5 of 2023, but she still also goes on her own via phone calls and DeLand and stuff like that with Ms. Kerbringer.
And has Ms. Ferbringer stayed in touch with you or answered any questions you might have related to probation?
Yes, if there's ever a question about traveling over to her, over to the county, because she has to leave Volusia County, she's on GPS, I would call Ms. Berger and confirm how she's doing, make sure the appointment's valid, etc.
And has Ms. Peterson met all of her financial sanctions?
She's currently up to date at this time.
Has she completed over half of her probation?
Yes, she has.
What would have been the halfway point?
It would have been June of this year.
And can you recommend early termination of her probation?
No, I cannot.
Why is that?
because it's a sex crime, and there's a physical victim in the case, so we always defer any early termination requests to the state attorney's office, and let them decide, and we just can testify to that, how they're doing on probation.
So is that more of a policy issue than a personal choice?
It's a policy we have to follow, yes.
And have you testified at prior hearings for Ms. Peterson?
Yes,
Have you had any objections or concerns in those hearings that you've expressed?
no concern, but the last, February of last year, I believe, was the same motion for early termination. I objected under the same circumstances I just mentioned. But just to roll it out here, and review to headward.
Yeah. All right, I can get a further question.
State, any questions?
Nothing from the state, thank you, Your Honor.
I have a couple of follow-up questions. So you started supervising her December 16, 2021?
Yes, upon her release from prison.
Okay, that was my question. So that is when she got released. So you've done community control as well as probation?
I've been in the same office for the whole time, yep.
Okay. And it looks like she came in May of 22 to modify the community control.
To get early terminated, correct. Which was granted,
Right.
and then,
So as of May of 22, essentially she started her probation return.
yes.
All right, any follow-up questions?
No, Your Honor.
No, Your Honor.
All right, thank you. All right, you can sit down. Any other witnesses for the defense?
No, Your Honor.
State, any witnesses?
No, Your Honor.
Argument from the defense?
Your Honor, I would present to the court some case law as well as a letter from Ms. Peterson, both of which have been provided to the city.
All right, any objection there from the state?
No, Your Honor.
All right, those will come in, defense exhibit. I'll do a composite, is that what you want?
That's fine.
Composite exhibit, defense exhibit.
And Your Honor, if I could, I'd just like to briefly go through what I feel the positions are on the case law and how it supports our motion.
Okay, give me just a moment. I'm sorry, the case law is not going to be exhibit, it's just going to be the letter. Give me just a moment to finish the letter. All right, go ahead.
I've provided the court and the state with 4 cases that I feel are appropriate to our situation. The first case is the newest case, and that's Parson v. State. It's a First District Court of Appeals from July of this year. And upon reading it, I believe the court would agree that this was a holding that essentially said the defense's appeal was dismissed on other grounds, but it notes that the court can early terminate probation under an older statute. It essentially supports our position that the 2018 version of 94804 would apply to this case.
I think the state has already agreed with that.
Yes. And the next case is Therian versus State, 914 Southern 2nd, 942. It's a Supreme Court case from 2005. Again, it says that the statutory law at the time of sentencing applied even on a sex offense. This explains that the state cannot appeal the court's decision to modify the conditions, even if it's a charge of violent felony offender of special concern. And the final case I provided is Lafayette v. State, 149 Southern 3rd, 662. It's another Supreme Court case from 2014, and it also holds that the state cannot appeal a court's decision to terminate sex offender probation early. And this was a situation where not only did the defendant never go to prison, it was actually in violation of a plea agreement where the defendant had agreed that she would not early terminate her probation. And the court essentially said that the court does not have to honor a plea bargain, the elements of a plea bargain, only the plea itself. So, based upon the reading of 94804 from 2018, based upon the testimony the court has had today, the character of the defendant, the witnesses, the fact that there have never been any violations to this probation, I would request that the court early terminate her probation, since she is past the halfway point and she meets all other conditions.
All right, State?
Your Honor, the state has made its record regarding objection to early termination based on our contact with the family of the victim and their wishes, and we will defer to the court. Thank you, Your Honor.
Ms. Klossner, can you tell me, is there anything in particular about her supervision right now that's interfering with her life in some significant way?
Yes, Your Honor. Sex offender probation requires the use of a GPS ankle monitor. This has significantly limited Ms. Peterson's her employment. She owns a company cleaning homes and businesses. She is essentially limited to Volusia County. If she wishes to work outside of the county, she has to get all the details about that location, provide them to Mr. Savalas, get that approved. She has to then notify him every time that she's planning to go out to that location. If she were not on probation and not on the ankle monitor, she'd be able to expand her business across the state, possibly even further, but for now she'd like to just stick to Florida. She'd be able to expand that and be a much more productive member of society.
Right. I'm going to tell you candidly, so I'm in my head sort of going back and forth on the seriousness of the facts of this case, and any concerns I would have about the community. And I can acknowledge she seems to be doing well, and so it's less of a concern than it normally would be. But the underlying facts and the charge itself are very concerning for the court as far as lifting any supervision.
The underlying facts of the case, I would ask the court to consider that they are extremely different from Ms. Peterson's life today. At that time, she was a much younger woman. She was starting out in her career field of teaching. She was in contact with multiple children. She was married, but going through a divorce. She had mental health issues that she was not addressing. And those things combined, they're not an excuse for what she did, but they certainly could have contributed to what happened. Today, she is much more independent. She has her own business that is completely different from what she was doing before. She's very aware, mainly, certainly because of the rules of probation, but she understands that for at least the next 25 years, if not more. She's going to be on the sex offender registry, and she's a convicted felon. She's still checking in with the sheriff's office, she's still checking in and registering at least every 6 months for practically the rest of her life. She now is in a situation where she is busy with her own job. She is not in a serious relationship, she's not married, she's not, running a household, raising children, she's not in a stressful position. Other than that, she is trying to expand her business, and trying to lead a much more normal life.
Sorry.
I was just gonna say, I just feel like the situation that she had then compared to what she is doing now and what she wants to do with her life now is so extremely different that I think is a key factor in assuring that the community would be safe if she were not on probation.
So, taking again into account of the seriousness of the charge as well as the seriousness of the facts alleged in the 77, you're asking the court to go from some stringent protections to basically almost no protection other than registering.
Unfortunately, there's not much in between. Ms. Peterson has done her prison time. She then followed it up with community control, which was cut at the halfway point because she had been so successful on it. I'd even asked the court to consider looking at those hearings and what Judge Nichols had to say about her, noting that this is just an exemplary performance from someone on community control, especially someone on community control with sex offender registry.
I think the fact that she had an early term on community control for a sex offense is, that says that to me, candidly, because those are ones we're pretty careful about.
Yes.
And those are usually, to be candid with you, the more concerning ones for us as far as why we have to have better protections to protect the community.
Yes. And Judge Nichols noted that she would have liked to have more of a step down for situations like this. Like she was considering taking her off the ankle monitor, but you can't.
Right.
It's an all or nothing thing on sex offender probation. So that is essentially the only step down, is granting her that freedom and believing that she will not screw that up. I mean, if she were to violate any part of the sex offender registry, especially if she were to do that after she was early terminated from conditions of her sentencing twice, I cannot imagine that the court would be sympathetic to that at all and that she would get some easy.
No, I recognize that. I think part of my point is though, she's getting some recognition for how well she's done and that she's not on community control and wasn't for the full 2 years. The other side of the coin is we have a victim who's deeply affected by this and likely will be for the foreseeable future. She was not charged, I saw, with any sort of contributing to the delinquency of a minor, I guess, but there's some allegations about, providing drugs to a child, and now the state is saying the child is dealing with addiction issues. So, even in considering the facts, how do you account for the victim's impact when you're asking for her return?
I was actually very surprised to hear the state say that the mother reported the victim was now dealing with drug abuse issues. When we were here last time and the mother testified, she had nothing but good things to say about her child. She
You're
went
saying
on
like,
about,
I'm sorry, you're talking about in 2024?
yes,
When you say last time?
yes, that how successful he was and how great he was doing despite what had happened to him. So, seems to almost be a 180, but yet trying to make the same argument.
All right, anything else on the things that I just brought up?
I would just ask this court to look closely at Ms. Peterson's letter. She does indicate in there that she makes no excuses for her behavior. She understands how much she has affected the family. This is not something that she will ever forget about, possibly not even forgive herself for. She not only created a situation for the victim, she created a situation for herself and her entire family that was affected by this as well. So, looking at the sentence that was given to her in total, the fact, I think, that Ms. Peterson has completed even more than half of even that total sentence should weigh into consideration in making this decision about early termination.
Thank you. All right, Steve, did you want to address any of the issues I just addressed with counsel?
No, Your Honor, thank you.
Let me see the attorney's side, Mark.
much.